Welcome back to the Conflict Counselor. Attorney mediator Chris Capocha here with you to discuss small claims court. The key things to know if you happen to become a plaintiff or defendant in the People's Court, otherwise known as small claims. First, a little background. More than 1 million small claims cases will be filed in the United States this year. In total, these actions will involve millions of dollars in damage awards, filing fees, and costs. So, while the individual claims are, well, small, taken together, they amount to big business for our judicial system. Let's divide today's discussion into two parts: small claims jurisdiction and small claims procedure. First, jurisdiction. In other words, what is the authority of small claims court and who does it serve? Small claims is a department in the civil division of your local district court. For a small claims case to be filed in the district court, the transaction must have occurred in, or the defendant must reside in, the geographical area served by the court. Small claims cases are confined to complaints for money damages only, not to exceed the amount established by each state, from a low of $2,500 in Kentucky to a high of $25,000 in Delaware. Now, many complaining parties are surprised to hear that damages for things like fraud, libel, assault, and emotional distress are not recoverable in small claims court. Small claims is truly the people's court for the adjudication of everyday money disputes. Common claims include those made by and against contractors, customers, landlords, tenants, service providers, retailers, debt collectors, neighbors, even friends and family. Let's turn now to small claims procedure. A small claims case is started with the filing of a complaint by the plaintiff against the defendant. Complaint forms may be obtained and completed online or in person at the appropriate district court. The filing fee is typically less than $100. The complaint must then be served on, meaning delivered to, the defendant. This may be accomplished by regular mail or a court officer process server. The court officer fee will vary according to what is necessary for proper service on the defendant. For example, the fee may easily exceed $100 if the defendant is evading service or cannot be located, a quite common situation. Once the defendant is served and proof of service is filed with the court, the case is scheduled for a hearing. If mediation is available, as in my court, the hearing is before a mediator, like me. If the court does not offer mediation, the hearing is before a judge or magistrate. The parties are instructed to come prepared with any documentation and witnesses to support their position. At the mediation hearing, the mediator helps the parties have an informal discussion to share relevant information, identify key issues, and negotiate a workable settlement which will end the case. If mediation is not available or does not produce a settlement, the case will proceed to a hearing before a judge. The judge will hear testimony, review the evidence, make factual and legal determinations, and render a decision, which will end the case. And here are a few more notable features about small claims court. An attorney may not participate in a small claims proceeding except on the attorney's own behalf. The parties have the right, before trial, to transfer the case from small claims to the general civil division. This may be done to allow for a greater damage award and attorney participation. Most importantly, the parties in small claims court waive some very fundamental rights. The rights to counsel, to a jury trial, to appeal, and to recovery exceeding the jurisdictional amount, all waived in small claims. I hope this brief tutorial about small claims court is helpful. Should you ever find yourself having to resolve a dispute in what is truly the people's court. Thanks again for tuning in to the Conflict Counselor podcast, which is available on most streaming platforms. As always, I welcome your questions and comments. Next time, we'll discuss why you should listen to the real Conflict Counselor podcast, this one right here, and not an artificial intelligence knockoff. See you then.